The Verdict is a live broadcast, and the opinions expressed by the host, guests, and callers are not necessarily those of this station. The references to legal matters are based on actual cases filed in federal and state courts and are matters of public record. Every legal situation is different, and none of the information or views provided during the taping of The Verdict are meant to be legal advice. For more information about The Verdict, please visit us at www.theverdicttv.com. Hello, and welcome to The Verdict, a show where lawyers take you behind the scenes as they prosecute the most action-packed legal cases around South Florida and New York. The Verdict is all about powerful insight and analysis about how to put the law on your side. If you want to call in, you can reach us at 888-565-1470 or write us on Facebook at The Verdict. Now, let's get down to justice. Here comes The Verdict with your hosts, Jay Farrow and Janine Davis.
Good evening and welcome to The Verdict. I'm your host, Jay Farrow.
And I'm your co-host, Janine Davis. Welcome, everybody. It is 6 p.m. on Monday, and we are live with you on the radio and live streaming on Facebook on The Verdict TV.
Awesome, and it is July the 8th, and we are live with you. This is The Verdict. This is the show that brings the ESPN plus Unsolved Mysteries. We're giving a voice to all of the cases in the legal system that don't necessarily make CNN, but should. We're also interrupting the practice of law, showing how we can get things done.
Jay, what do you mean by that when you say interrupting the practice of law? What does that even mean?
The practice of law, I'm talking about taking an hammer to it. I'm talking about, why does it take so long? Why does litigation take so long?
Why does it take so long?
Well, is it possible that there's a better way to practice law, to make it more efficient, to have a client-based practice of law as opposed to a lawyer-based practice of law? And what I mean by that is that when I talk about disrupting the practice of law, and we're traveling today, we're actually in Hollywood, Florida.
We're in a remote studio in Hollywood, Florida.
And we're looking to take this show to different communities. South Florida, we're starting with, and we're looking to talk about the interruption of the practice of law. It talks about a lot of things. It's a David versus Goliath story, really. Okay.
And it's really challenging the status quo.
Yes.
I mean, that's really what we're talking about here.
We're giving a voice to those that wouldn't necessarily have a voice. And the way that we're doing that is we're calling lawyers out. And I've been practicing law for over 15 years. I do commercial litigation, and I've done over 100 appeals. I mean, I've done my share of hard-nosed litigation. And I know that there's a better way. And I know that a lot of people don't think that they have a shot because they go up against the big corporation, or they go up against the people that have been doing business a certain way for a very, very long time, and they're an employee and they don't feel like they have a voice. Well, I'll tell you right now, you do have a voice. And we're going to give you the opportunity to go inside some action-packed cases and show you how David goes up against Goliath.
Absolutely. And speaking into that, too, about how people think that they don't have a voice, it's not only a question of the finances, but people do not want to trade the time. They think it's not worth it because the reputation of people in litigation is that it's protracted always. And by protracted, we mean years.
Years.
Not months, years of litigation. So not only does it hurt people do not want to be hijacked with the worry of litigation for years and years.
Well, here's one of the thoughts that I had some months ago was that technology has given lawyers the opportunity to do what would have otherwise taken them 20 hours in 20 minutes. And what I mean by that is that we have so many tools available to us that weren't even available to me when I graduated from law school. Or if they were, they didn't have the capabilities that they do today. I'm talking about legal research. I'm talking about the electronic filing systems that we have with the clerk's office now. We have all of these technological advances that would shorten the amount of time that lawyers would take to do certain actions, but yet the court system still takes between an average of 3 to 5 years to handle a complex commercial litigation case.
Absolutely.
And when you're going up against Goliath, and let's say I'm a solo practitioner, and if I'm going up against a large law firm, let's say, I mean, the concept, the thought is that they're going to drag things out. And I do have a couple of cases we're going to talk about my own cases today.
Yeah,
that we're going to give you examples. By example, what happens when David goes up against Goliath.
Right, right.
But the concept or the thought is that if one side can spend more money, they can hire more lawyers, and it's true. What
It
people
is
don't
true.
realize,
Absolutely.
there's no law out there that says you can't have 10 lawyers against one lawyer.
Right, right.
Okay, and a lot of lawyers get intimidated by that. And a lot of
Right.
lawyers would throw someone out of their office, per se, to say, look, I'm not going to be able to take on this case because, we're going up against, or the odds of going up against this large law firm it's just too much. And do you really, have the means to take them on?
Right.
But I mean, from the client saying, hey, do you have the money to do it? And there's certainly there are ways to do it. Now, I got to thinking about my cases, and the question is like, why are we here? Why are we doing what we're doing here on this show?
Right, because it warrants mentioning, too, that you are the attorney. I
Yes.
am not an attorney. I am the lay person in the office. I'm actually a life coach, but I'm also here because I'm a passionate advocate for people. And I'm here to also bridge the language and ask questions on behalf of a lay person to an attorney and have access to that and ultimately make it more accessible and less intimidating.
I like the word accessible because that's really what we're talking about. We're making an authentic show about a lawyer that's talking about what he sees wrong with the way the lawyers are acting. Because I'm here to call myself out as much as any of the other lawyers are saying, how can we make this easier? Because listen, no matter who's on what side of a lawsuit, people are losing sleep. That's a fact.
It is an absolute...
And even the people on the other side that are the Goliaths are losing sleep. Okay, because there's nothing that challenges a psyche more than uncertainty. As I say, there's nothing that challenges a person's psyche more than uncertainty. And litigation breeds uncertainty, and it's the uncertainty about the process, it's uncertainty about the players, it's uncertainty about the person who's wearing the black robe, because you just never know. I mean, litigation is 100% of a crapshoot, and we have more examples that we're going to talk about a little bit later.
Absolutely, yes. We have a couple of examples in the office that have just occurred,
Just
actually. As luck would have it, or not luck at all, in fact, but as life would happen.
As life would have it.
And it warrants really mentioning all of the different variables that can go in. And this is something, as I was drafting an email to a client, the first line of the email is, we cannot guarantee a result. You must know that.
Right.
Again, because there are so many different variables, and people get to know this, and this is what people are afraid of. However, this is a metaphor for life, and this is no reason not to empower yourself to do something about a situation that has cost you money, anguish, and that you've been the perpetrator, or you've been the victim of a fraud or a breach of contract, or any number of things that could go on that would warrant the aid of a lawyer.
So we've created a show to talk about how lawyers become more efficient, how the law can be more client-based, and also how David can take on Goliath. I want my listeners out there to hear this, and this is important. We're really creating the show for you. So we created the show that no matter what legal challenge you might be going through, no matter how insurmountable the odds may seem, because that's the way they were told to you, no matter how much money the other side has, you got a shot, you have a voice. It's never a matter of a lack of resources. It's a matter of lack of resourcefulness. And I can say that multiple times, and I say it again. I mean, a lawyer never lacks resources, they lack resourcefulness. Because that's what we need to get down to it. Okay, at my firm, we don't have the quote unquote resources that a firm with 1,000 lawyers have. But I have something that I think that works for me.
Yeah.
I got heart. I got
Heart, ingenuity.
Ingenuity, 20 hours a day, and now we have a show to talk about not only my practice, and my practice is only one of tens of thousands out there.
Absolutely.
That are the law firms that have one lawyer, maybe 3 lawyers, maybe 10. Let me show you that nothing is impossible. You do have a voice. And I think that the first thing that we're going to do is we'll talk about some of the cases that we have, and you'll be like, whoa, you're a solo practitioner and you got these cases.
Yeah, it's really
multi-million-dollar cases.
But you said something really important. So this show is for the public. It's for people out there. But it's also, Jay, for other attorneys. Why? Because even though we will point out the defects of the practice of other attorneys, the point is to also create the conversation and the dialogue about what's possible for other attorneys, keeping in mind their health, their unknowing addiction to the billable hour, and all of these other things. They have been trained to practice law this way.
Right.
So, but it's not because there's something fatally wrong with them or anything like that. So I think it's really important, while we're pointing out the defects that we see it from our point of view, also to be cognizant that we are also in service to opposing counsel. They too can benefit from the way that we are, the point of view of how you manage the practice.
Right, and you mentioned the addiction to the billable hour.
Right.
And this is something we're going to talk about constantly on
Ad
this case.
nauseum, people, prepare yourselves, because that's
Because the system has been built on the back of the billable hour. And the billable hour is by far the one thing that gets in the middle of a client getting a result and a case
Absolutely.
taking 3 to 5 years to resolve. And it's because certain law firms, the Goliath law firms, are built upon this billable hour concept. Okay,
Absolutely.
is the reason why
The attorney
everything
is a
grounded up.
workhorse.
And I've
That's
worked
it.
for these large law firms. Okay, I've worked, one in particular. I mean, and I'm just telling you that the way that the billable hour supports the delays in the law it's not acceptable anymore. It's just not acceptable.
Right.
It's not acceptable because the client should come first. That's the oath that we take. That's the bottom line, is that the client should come first. But then when you start going down to every single second that you have to bill, your inventory is your time, as they say. There's a better way to do it.
There is a better way, and again, also in service to attorneys and to attorneys' health. That is part of the point
Right.
of view of the show.
I would say this. A lot of young lawyers, they graduate law school and they do go to work for larger firms. And there's nothing wrong with that experience, and they do great work when they're there. They learn how to write, and they learn how to research and everything, and a lot of things. But the billable hour requirements of some of these law firms are 2,400 hours a year, 2,200 hours a year. To put that in perspective, I mean, that's like 40 hours a week, 42 hours a week billed. You didn't figure that you have to be there for a lot longer than that.
At least twice as long
Right,
in
so-
order to bill that amount of hours.
So I know what the billable hour did to me. I mean, and how it affected my health.
Right.
And I'm saying that underlying all this, when we talk about disrupting the practice of law, it's not just to beat the other side. It's
Absolutely.
not just to support
Correct,
the client.
which is
but
why I
it's
wanted to
also
mention it. It bears mentioning.
It bears mention that we're all looking to support the lawyer's health as well. So we get a win-win-win situation here. Because
Absolutely.
getting cases done and in and out on with life is what we're going to talk about. So we're going to take a couple-minute break here. And on the other side of the break, we're going to talk about some of the cases and then some of the vision for the show.
Absolutely.
We do have a guest that's going to be coming here a little bit later in the show, and we're excited for that. We'll see you right at the other side of this break.
NN.
The following program does not necessarily reflect the opinions of the staff, management, ownership of the station.
Farrell Law Firm, standing up to corporate bullies, using innovative, aggressive, and effective strategies to resolve disputes effectively and timely. Contact us at 954-252-9818, online at farrelllawfirm.com, and on Facebook at Farrell Law Firm. We look forward to being of service to you.
For psychological or mental health advice. If you are
NN.
You have been watching The Verdict with Jay Farrell and Janine Davis. If you want to call into the show, you can reach us at 888-565-1470 or write us live on Facebook at The Verdict. Now, back to The Verdict.
does not necessarily reflect
Welcome back to The Verdict at Monday afternoon. And we are on location in Hollywood, Florida. And I see that our guest has joined us. This
Yeah,
is,
we're very pleased to have our guest
my-
sooner than expected.
my good friend, and I call him a lawyer's lawyer. This is Sar Dunbar.
Thank you.
And thank you for joining us again. And we were just going over the vision for the show, some of the things and our thoughts of what we're going to be doing with it. You know, supporting the concept of getting in and on with life with cases.
Right.
And right before the break, we started to talk about some of the things that we think that get in the way of that is the billable hour itself. And how some firms are built upon that model, and unless that shifts, shifting to a concept of getting something done in 6 months as opposed to 6 years is going to be difficult to happen.
Right. I mean, you think about it, state court, most of the time things move really slow.
Right.
You know, you have state court judges, and there's all these cases being filed. It's a different situation in federal court where they have this rocket docket. And a lot of the times, to move cases along, you got to have a strategy.
Right.
And oftentimes, when you're the plaintiff, you can set a case for trial. That's going to move a case fast. And usually, defendants, they want to slow down the case, obviously, because the longer the case goes, the less likelihood is that people remember, witnesses forget, and they have the burden of proof. So one of the things I like to do is, you do pre-mediation before you go to trial, or during mediation, the first thing I file is a motion to compel mediation. That gets the parties right talking to each other before they spend a whole bunch of money, and that might actually result in a quicker resolution than later.
So, Sarah, question for you. When you say motion to compel mediation,
Right.
does the other side have to agree, or is it up to the court ultimately on who says what?
So I have never had a motion to compel that was opposed.
Okay, excellent.
So
okay.
to answer your question, it's basically a rubber stamp, and what I like to do is file that first, let them know, listen, I want to resolve this with the other side. I also want to get in front of the judge and let the judge know I'm not here to do the billable hour thing.
Exactly.
You know,
The
like
milk
we
the
were talking
cow
about in
kind
your first
of.
segment.
We were talking about just about becoming more resourceful.
Right.
Because it's not about having the resources. It's doing things like this. A motion to compel mediation or setting something down for mediation at the beginning of the case.
Right.
I mean, that has the potential to get something resolved. Now, you're also a certified Supreme Court state mediator. Is that
That's correct, yeah, since 2010.
Okay.
So
So you've seen it from all sides.
I have.
Now, have you seen, though, a push in the beginning of a case to try to get something resolved and they go to the mediation in the beginning of the case?
The most effective mediations and resolutions that I've seen is where you have something hanging over the other side. So
Such as?
such as a deposition, discovery, experts set the next day. I've seen cases.
Something that will create dread.
Exactly. When you have something hanging over somebody's head,
Oh,
you have a.
I was saying that we're going to talk about some of the cases I have, and the vision of the show is to bring other lawyers in to talk about their cases, the David versus Goliath story, the cases that didn't make CNN, that should have made CNN.
Right.
I have two cases in particular, and you want to talk about dread, right?
Oh, my
I just
goodness.
want to. I have a case. It's against Insurance Office of America and John Rittenauer and company, and I filed this case about 7 weeks ago now, and I got the initial stuff, the motion for extension of time to file a response to complaint.
Right.
I've gotten a motion for extension of time to respond to discovery because I served my discovery out quickly.
Right.
And for those of you, I know that I might be talking quick. So that's basically, I sent out a bunch of information requests that I'm entitled to at the beginning of the case to try to push the case along. And they blew the deadline on that. They filed a motion for
Right.
extension of time.
So one of the things pardon me, Jay, excuse me, one of the things that I noticed when I started working in this field is that there was a lot of motions for extension of time, and I would always say, hey, you do realize in the real world, there is no such thing. Like, the grace that you guys have in order to do this constantly, and granted, I now realize that some of it is very strategic and in service to the client on some level. However, in real life, a deadline is a deadline is a deadline.
Right.
Not in the law.
So everything's a negotiation. So if I'm going to give you an extension of time, I got to get something in return.
Right.
Right.
So if you're asking for an extension of time, okay, you're going to have an order that's going to give you a certain amount of time. And why do I like to have an order? Because if they violate the order, we can do an order to show cause. But if I grant the motion of extension of time just as an email, then I got to go to court again to enforce it, and then another hearing for an order to show cause.
See, there is a way to strategize. There's a way to set this up from get-go. In other words, you have your tolerances. Like, I know that, okay, the first motion for extension of time, it's like almost like a courtesy, but like to your point,
Right.
I'm getting something in return for that. And if I'm not getting something in return for that, then they're going to have to go to court and run that. But I've been a little bit too nice in my career. I'm not doing that anymore.
Yeah.
So, Jay, you're very graceful to the other side, absolutely. And sometimes they're just like, okay, we'll note that you object. What? Okay.
Right.
Because this is exactly what they're used to. They don't even know what to do differently.
And and that's part of it. Like, I'm thinking about, like, how do I get things moving? I got a TV show now.
Well, you know what's funny? I've done a situation where I played good cop, bad cop.
Okay.
And what I mean by that is, if someone will ask me for extension of time, I say, you know what, I would love to do it, but my client's giving me a hard time.
Right.
He really wants to set this down. Maybe I can convince him to give you 15 as opposed to 10, but he's requiring you to do it in order. It's that kind of thing that I go back and forth with
I like
opposing
that.
counsel.
I got the opposite
Yeah.
thing. I have a client who is like that. Like, I'm not giving them anything. I mean, you rip me off for $10 million or $6 million. I'm not giving in for a second.
Right.
We have that, though. We have that balance, right?
Right.
With our
It is
clients,
creating a balance
because
to be
we know what the judge is going to
you
do
know?
anyway. If you go in before the court on a motion for extension of time, you know what's going to happen is the judge is going to say, why are we here? Why don't you work this out beforehand? And it's really hard to tell the judge, well, my client didn't want to.
Well, depending on the judge. If I have Judge, I want to move this along.
Right.
I got pending discovery. I don't want this case to drag on. As soon as you say that to a judge, they're going to, next time you have something, they may grant them the extension
Right.
or may not give them as many days, but you come back before them on something else,
Right.
they're going to go in your.
Well, and you bring up a very interesting thing. So, again, this is a profession full of human beings. So, a lot of it does depend on the judge.
Right.
Sometimes they had a disagreeable morning, and you will see the results of that. They may not see it your way. And so, this is also the risk of not sorting it out civilly amongst yourselves using the tools of mediation, using all of the different tools of negotiation afforded to attorneys prior to getting it before the black robe.
Now, if I'm talking about interrupting the practice of law, okay, that means from get-go. In other words, I've now created a strategy in this case against Insurance Office of America and in this other case against Fly Victor, where I know where I'm at exactly in the case right now. It's really like one of the first times
Absolutely.
where I've looked to say, okay, I know the other side's using the billable hour. I know what they're doing, and I know. Look, I'm looking at the beginnings of how their strategy is to grind this thing out, because they don't care. I mean, this guy is a professional as far as litigation is concerned. I found other cases around the country that they're involved with, and it's the same MO. I get to now implement the different strategy, and for me personally, it's also going against the grain of that thought as well. I'm not being civil enough. Well, really, but my client's out of money. I mean, this is a racketeering
Right.
charge that I have in this particular
Right.
case.
These are very serious
This is very
charges.
serious charges, so it's not like this is a straight up breach of contract. So I get to be, it's not a matter of necessarily being more aggressive, but more intentional about
Correct.
what I'm actually going to be allowing to go on in the case. Because there's a lot of discovery. This case could legitimately go on for that 3 to 5 years. It's up to me not to allow that to happen.
Correct.
So now, we're talking about these things, and for you lawyers that are joining us, I mean, a lot of stuff should be clicking in, like, oh yeah, I understand what that is, and I understand that. So we do have a Facebook page. So if you wanted to write in to us on Facebook, it's at the Verdict TV Show, and we'll be happy to answer your questions. If you have a specific legal question, understand that we really are not looking to answer specific legal questions on here, because every legal situation is different.
Right.
And
Again, can't guarantee a result.
but as
No lawyer can.
No,
That's right.
Yeah.
No,
That's
but
right.
on the broad strokes, we're looking to create the drum beat that there is a way to practice law that is built upon the concept of urgency as opposed to the concept of let's just the delay. I mean, you see it.
Yeah, it's incredible. And again, in real life, it doesn't exist. These delays don't exist like that. It's the law in construction.
But I like
That's what I'm saying.
I like Sarah's perspective here, because you've handled how many mediations?
I mean, hundreds. I mean, and as a litigator, I've been a participant to at least thousands. So, I've seen all different types of sides. And what's consistent in all of this is leverage, pressure bust pipes, and you gotta apply pressure. It's not even about being civil. Everything that I say, I put it in an email. I learned a lesson a long time ago when I was first or second year, is that what you say doesn't necessarily mean anything unless it's in writing. And that goes with the opposing counsel.
Right.
Because at the end of the day, you got to understand that whatever you say or during the case, it only matters if you can prove it and write it.
Right, and it's a jungle out there. I just had it out with an opposing counsel on the case that we went to trial last week,
Yeah.
and he just questioned my ethics in an email.
Right.
And this is something else I want to get off my chest. Listen, I don't mind talking about this stuff because it's out there, it's real, it's in your face, and as a practicing attorney, it's shocking what you get from another lawyer. It's unacceptable what you get from another lawyer. And I wouldn't put into an email some of the things that I just got today.
Right.
Implying things to my ethics and to this and to that. And I finally said, no, we're taking this one up before the judge, because
Right.
I've actually had it with this particular individual. But
Right.
to your point, I mean, I put it in writing. Just go before be right before the judge.
Right. You always, listen, you never let up till you sweat. Okay? And that goes with the practice of law or anything that you do, especially opposing counsel, because as soon as they know what buttons to push, they will apply that pressure.
Right.
But if you don't give them that thing that they're trying to frustrate you about, they lose all their power. And so now it comes straight down to that 4-page box. It doesn't matter how big the law firm is. You can only send one email at a time.
Right.
There are 1,000 lawyers. You can only send one email at a time. You're going to do one pleading at a time.
And you can only go to one hearing at a time.
Exactly.
Right.
So you just got
And
to be
there's only-
strategic about it.
There's only one judge on top of the hearing, but
Right.
but there are some times that it comes down to that. We're going to court.
Right.
That's something that you got to be prepared.
I
You
give
got to be
you
ready
all
to
a
go.
lot of
and-
credit because, a lot of the things that you all experience would really, in most cases, end up in a street fight. I mean, it would just really, the lack of civility and the lack of logic, really, and the lack of consideration, again, to the client for the sake of the ego or the agenda of the attorney is something that is really, truly shocking.
Well, I was saying the lawyer's health is one of the things that this show hopes to promote.
Absolutely.
And it affects me. However you want to look at it, over a period of time, you get these things. You take it, you take it with a grain of salt. I mean, I eat well, I exercise, but sometimes you take this stuff home with you, and it's like, and it's because the other side is going through as much pressure as you are. And I have a theory that it's because of a couple of things, but the uncertainty of litigation breeds the incivility. Because we can't guarantee anything to our clients.
Right.
We don't know what's going to happen.
Yeah.
Right?
I mean, I
There's
had
so many variables. How can you?
I had a judge rule one way in a case last week, and it was contrary to what the law actually says. And
Right.
but that happens, and that's what the appellate courts are for.
Well,
But-
we're going to talk a little bit more about that because that is something that we wanted to discuss regarding unforced errors. There was a reason or something that happened
Oh,
with
yeah.
the client that set that up for the judge to actually systematically ignore the black letter of the law.
Well,
because of the client's
And as we
behavior.
talk more and more here, I want to get into Sard's field about mediation on the other side of this break. We're going to take a break right now and then talk about like the benefits of the resolution process as opposed to all the things that we're just talking about now, the judge's decision, the unforced error from the client, the emails from the other side. All of that can be avoided, and also the sleepless nights that our clients go through on any side of this
Right.
can be avoided by attempting to resolve the case at a mediation. We'll talk about this on the other side of the break.
Stay tuned, everybody.
All right.
The following program does not necessarily reflect the opinions of the staff, management, ownership of the station. Jay and Janine are expressing their
Farrell Law Firm, standing up to corporate bullies, using innovative, aggressive, and effective strategies to resolve disputes effectively and timely. Contact us at 954-252-9818, online at farrelllawfirm.com, and on Facebook at Farrell Law Firm. We look forward to being of service to you.
The following program does not necessarily reflect the opinions of the staff, management.
You have been watching The Verdict with Jay Farrell and Janine Davis. If you want to call into the show, you can reach us at 888-565-1470 or write us live on Facebook at The Verdict. Now, back to The Verdict.
Jay and Janine are expressing their own opinions.
To The Verdict. I'm your host, Jay Farrow.
And I am Janine Davis,
And
and
we
we have
are-
our guest here, Sar Dunbar.
We're with
Hello,
Sar
everybody.
Dunbar. We are live in Hollywood, Florida, and we're looking to take this show, right now just around South Florida, but also around the country potentially.
Yeah.
Talk to other lawyers about the cases that they had that didn't make CNN. They're David versus Goliath stories. And right now we're talking a little bit before the break about the possibility of avoiding the whole circus of litigation and in favor of the mediation process. And SAR is a certified Supreme Court state mediator, and you said about 80 to 100 mediations that you've...
At least.
So mediation is a process by which someone like SAR can oversee or navigate through the resolution of a case through the parties getting together outside of the courtroom, and just tell their stories to you first, or how do you see it?
So essentially, as a mediator, you're a neutral. You're not a judge, you're not an attorney, you're not advocating for either side, but it's a quasi-judicial system because what you're trying to do is facilitate a resolution outside of court. So the rules are a little bit different in mediation. There's different types of confidentiality, or the confidentiality amongst all the parties. Nothing can be repeated in court or to anyone else outside of the mediation.
Completely confidential.
Exactly. And then sometimes the mediator will break up the parties or the attorneys into what's called caucus. And caucus is basically you have one side and the mediator, and they try to reach some sort of, an offer to one side or the other, try to reach a resolution. And that caucus is also confidential from the other side and the rest of the world.
So let me ask you a question.
Sure.
When the parties initially get together in front of you,
Right.
and they tell you their side of the story,
Right.
have you seen it where they sit a little bit longer? In other words, instead of breaking off into a separate room, they said, you know what, wait a second, now that we have the people that are here,
Right.
let's take some more time with this and maybe, resolve it here. Or, because sometimes, and in my experience, a lot of people just want to run into that room,
Yeah.
and be by themselves.
It's sort of like a poker game. So for me, I'm looking at the eyes of everybody. Are they making eye contact? Do they like each other? Do they dislike each other? Do the lawyers like each other? Are people paying attention when they're talking to each other? And that really determines whether or not I keep people in caucus or, bring them together, per se.
So you're the one who's deciding.
I'm deciding, yeah, from as soon as I walk in, do they handshake? Do they look at me? Do they not look at me? Sometimes if it's at my office, I'll offer something to drink. Depending on whether they want something to drink or not, I'll make a determination.
Wow.
Yeah, it's a lot. I mean, understand we have to go through all these classes as a mediator.
Okay.
And they go through what's called your power base, and everybody has a different power base and what they're bringing to the mediation, and you can kind of tell whether someone really is who they say they are or they're just bluffing. And so you kind of use that in a way to try to facilitate a
So
resolution.
there's a lot of psychology here
Absolutely.
and observing.
Yes.
Yeah.
And it's not that everybody wants to show up to mediation.
Right.
I had this case against this company in London now, Fly Victor, and all of my cases, I attempt to resolve things beforehand. I send out a complaint, I send out a demand letter, I send out my evidence, my expert reports. I'm like, here you go. This is what it looks like on paper. Let's see about sitting down and resolving this case.
Right.
Not everybody takes it. Nine times out of
No.
10, I'll acknowledge that the people on the other side in my cases have accepted that. Fly Victor, I don't know what's going on with you guys.
So I think some people
But-
don't want to admit to any wrongdoing.
but-
Therefore, they don't even want to go down the tracks. I think
But just to
mediation
show
makes
up,
them feel.
just to show up's a big deal, and I'm saying this to get my client there. It's a big deal because they're actually taking a step to getting the case resolved. And believe it or not, a lot of people don't want their cases resolved that quickly. There's something about the finality of everything that they don't want it. But I've mediated cases with SAR, and I didn't know that you were paying that much attention to.
Oh, you have no idea.
But that's good to it's good to know.
Very good to know.
Yeah.
Because by the time I'm getting to mediation, I've prepared my client that, look, you're not, all that thought about your home run case, it's always a possibility, but let's get off that.
Right.
Okay? And let's get real about resolving your case today. Because
Right.
there's a power in resolving your case today.
Right.
My question to you is a couple. One is, have you seen it that people will sit in that room longer or want to, or you say you're taking more of that away from them?
Well, it depends. So if the attorneys are dominant, what I call, they want to control everything, then you kind of have to play that.
Okay.
If one attorney, they may not be more dominant, but they want to appear dominant, I will caucus with the other side.
Okay?
Okay? Kind of to try to make them feel at ease and kind of humble them a little bit. Because if I caucus with them first, they're going to try to dictate the way the mediation goes. So I want to take their power away to kind of balance it
Got it.
out. And I might even stay in caucus longer with the other side just to let them know who's really in
Right.
charge of the mediation.
Got it.
And it may not go exactly
Why?
how they
Because
want
they'll
to go.
try to steamroll over you.
They
as
may try to
well?
steamroll over
Got
me.
it.
They may try to,
Because people don't show up. They show up for a fight. They show up. They're ready.
Right.
On the other side, I've seen them angry. I've seen them jacked up. Or I've seen them very timid. And because all of our personalities come out.
Yeah, you cannot hide who you
can't
are-
hide
who you are.
Hide who you are. You're now in a room, a smaller room. You don't have that court, which is like a whole new. That's like a context in and of itself. And you're there, and SAR's there, and SAR starts off, and you explain what goes on at
Right.
mediation. But then it's your turn, and then you're delivering, what you're basically saying stuff that your client wants to say.
Right.
But
Correct.
and then you're listening from the other side, and I've heard it, all kinds of stuff from them. But what do you think is the most effective thing to have with you at, in other words, preparing my client for best case, worst case scenario, or is it that something that happens? Is it case law? Is it what are some of the things?
It's a great question. And preparedness. And there's two types of preparedness. You have to be prepared, obviously, as an attorney. Know the law, know the other side, and preparing your client for what to expect.
Always the human aspect.
It is going to be a roller coaster in mediation.
Because you're not going to get that offer that you think that you're going to get. You're going to get, if you're asking for $10 million, you're going to get a $1,000 offer potentially.
And what I always tell when I'm the attorney and I'm in mediation, I always tell my client, show no emotion. Don't react to anything. Because they're trying to size you up as well and see what to tell. Whether you're going to blink on certain things that get under your skin. Sometimes people use mediation to see how you're going to be in a deposition.
Right.
So you always got to have your guard up when you're the attorney and also preparing for your client. But case law, and I think I've talked about that before,
Right.
is the most persuasive. Now, some attorneys, they don't care what the law says. It's like, you go high, I go low, let's reach in the middle. You'll know that very early on when you're mediating a case. But to me, the cases that settle is when you have a case law. Because I don't care what anybody says, how good of a lawyer they are, their opinion of the case law. The law says what the law says.
The law says what the law says. What about the external factors, though? And this is what I'm talking about with my cases right now. How is it that the people on the other side, they did something wrong?
Right.
I
So what matters to them?
But
It goes back to
what
the
about
power base.
what about the business? What about the value of the business?
Right.
What about if they have 1,000 employees that are depending on them
Right,
making
so-
correct decisions for them?
Right.
How do you enroll somebody into that conversation of, hey, it's not just who's right about the law.
Right.
Because judges get
And it's not just about the immediate plaintiff, because the plaintiff is responsible to thousands of employees.
Right.
Employees who have families, employees who have responsibilities, employees who are counting on that. So they're gambling with something that they actually don't really have the right to gamble with, which is other people's livelihood
Right.
for the sake of their ego. And this is really the biggest story here.
Right.
It's not about the law. Yeah, they did something wrong. Yeah, they need to pay the piper, the whole thing. But it's even deeper than that. It's bigger than that.
Then how do you show that? I mean, how do you show that? Because I have it on paper. I can show you,
So-
how businesses can crash, how businesses might not be around next year because of what just happened in a couple of my cases.
So
That's a fact.
So everybody has a favorite TV show. And from an analogy, you got to find out what the other side's favorite TV show is. Okay? What makes them tick? What makes them get up in the morning? Some people, it's money. The bigger the giant, sometimes money may not be an issue, but sometimes it's stress, how long it's going to last, the uncertainty like you talked about before, but even more importantly, bad publicity. Reputation is not something necessarily you can put a
You
dollar,
Yeah,
amount
you
on
cannot
it.
This
buy
is
your
where I think
reputation
lawyers
once it's
fail their
soiled.
clients. I think they become so right about the law. We all went to law school. We all have the ability to go to Westlaw and check out what the law is. And well, you could disagree.
Yeah.
We know more or less,
Right.
which side we're on, or if we're grasping for straws.
Right.
I mean, there's very rare situations where,
Yeah.
you can make your argument. That's what our job is.
Right.
But I think that's where I've seen most lawyers fail their clients is how right they are about the law. How expensive is it to try to be right about the law?
That's it, but also you got to understand what are their risk factors. Is this person willing to take risk? So if they are willing to take risk, it's not enough to say that if you put your hand in the oven, it's going to burn. You might actually have to burn it a little bit
Right.
while you get to
Absolutely.
mediation. That's why I say have something hanging over their head by this is what we're going to do. Sometimes I might even have a second mediation. I'll say, Judge, you know what? We'll pay for the second one after I take a deposition.
Right.
Just to let them know that this is what it's like to burn your hand a little bit, and this is what we're going to have to go through.
Now, let me ask you a question. I'm glad you brought that up because I had this thought in my head the other day. What about a continuing mediation? And what I mean by that is that a mediation you set for one day, you can start it. But
Right.
the mediator's job, there's no resolution. When
There's an impasse.
Right. If there's an impasse that day,
Right.
Have you ever seen it where the parties would agree to say, "All right, I'm going to keep you on call for the entire case."
Right.
Where you actually ask the judge to have a mediator appointed on an ongoing basis. In other words, the mediation doesn't start on a day, it doesn't
Does
end on
that
a day.
exist?
It's called an adjournment, essentially. I had one as an attorney.
Okay.
Went on for 2 weeks.
All right.
Going back and forth, and we settled. It was a fascinating experience. I always are in favor of that, and what you're really looking for is a triggering event. Meaning, is there a motion for summary judgment where one side thinks they're going to win and the other side thinks they're going to lose? And if one side loses, that significantly shifts how you're going to
So
negotiate.
explain to the public what a motion for summary judgment is, because that's not a,
It's
something you
basically
hear
having
every
a trial
day.
without a judge. I mean, you no longer have a trial. The judge just decides that there's no issues of material fact. Is that?
Yeah, so I usually give the example
What does even
of,
that mean? A material fact for what?
of a car crash, right? So
Okay.
when you have a car crash and the issue is like, well, I think the light is red, you think the light is green.
Okay.
Well, if both people agree that the light was red, you don't need to go to trial on whether the light was red or not. Okay?
Right.
So a motion for summary judgment would be, Judge, we don't need to go to trial because both parties agreed that the light was red. The only thing we're talking about is what the damage was once this person went through the red light and damaged my car.
Got it.
That's the simplest example I've given my clients.
And that
to explain
exists in
motion
all
for summary
kinds
judgment.
where you say that there was.
That's
like,
awesome because,
if
again-
one party was supposed to deliver 4 red cars and they delivered 3, so they breached the contract. You don't have to decide whether or not there's a breach of contract. It's a breach of contract. The question is, what are the damages? So there's cases that can be decided by a judge on what's called papers. But my question more was like, and again, this is just a thought,
Right.
about having a mediator appointed over a case, agreed upon by the parties, that basically could be on call, like a go-to, like, hey, I just got this. For instance, let's say, imagine this, and I might be bringing this up on a show coming up next week, let's say, I don't know, a witness was tampered with, okay? And you find that out. You call the mediator and say, listen, I don't know if I want to pass this on to the other side or not, but this is where I'm at. Because you, as a mediator, might have a tinge of a hint of how they would settle if, in other words, if I'm a lawyer and I told you and you're the mediator and you're going through this continuing mediation. Again, I'm just a thought.
Right.
And I've already shared with you my clients on the fence here, you know.
Right.
But an issue came up, and it's like, if someone like, could be witness tampering, could be that we found out some additional information,
Right.
and I call you up as a mediator, and I was, listen, I got what you thought, you know, I got that extra push.
Right.
That the other side is going to settle for, you know,
Right.
and then you could make the phone call and say, listen, they got X, Y, and Z. Just want you to know that.
Right.
You know, so in other words, you're not having a date certain for mediation. You're actually having it on a continuing basis, and it might be something that, you know, could possibly open up conversations that weren't necessarily open.
You usually see that in third-party, four-party lawsuits.
Okay.
Where you have a mediator that's appointed to resolve multiple claims. You know, oftentimes you want to have it done in one day because
Right.
it puts pressure on everybody. It's more of an incentive. If people know that you can go more than one day, they're
Right, it
odds
gets
are they don't
dragged
want to
out.
ride. They
But
don't want to
if it-
resolve
But
it.
so
in
you
one
say
day.
there could be an adjournment,
Right.
okay, and some major issues come up in a case,
Right.
and like, you know, it could be witness tampering. I don't know.
So that actually speaks into the unforced errors that
Right.
we want to get into possibly at the other side of this, our next upcoming break, because both sides make the unforced errors.
We're going back to the uncertainty principle.
Yeah, again, it becomes apparent
when I talk about the
over and
uncertainty
over
principle in
again.
litigation is simply this: we're all people doing this job.
Right.
Just because we're lawyers doesn't make us right. Judges, I mean, just because they're judges doesn't make them right. We're all people doing the job that we have, and there's no guarantees. And like I think on our first show, you pointed out, this is all just paper.
It is.
Yeah.
No matter if the paper
And it's
is
the
asking
interpretation
for
of
$1
the
million,
paper sometimes.
Right.
if the paper's asking for $1 million, if it's asking for $10, it's a piece of paper asking for this from the court.
Right.
And we don't know if we're right or wrong. I don't even know if there is right or wrong, so much as what comes down at the end of the day as a decision
Correct.
on a case.
Right.
So I want again, on the other side of this break, I want to talk about the uncertainty principle a little bit. Wrap it up about the mediation piece, and maybe get into a couple of the cases that we're working with right now. We'll see you on the other side of this break.
Stay tuned with
Sounds
us.
good.
NN.
program is not necessary.
Farrow Law Firm, standing up to corporate bullies, using innovative, aggressive, and effective strategies to resolve disputes effectively and timely. Contact us at 954-252-9818, online at farrowlawfirm.com, and on Facebook at Farrow Law. We look forward to being of service to you. You have been watching The Verdict with Jay Farrow and Janine Davis. If you want to call into the show, you can reach us at 888-565-1470 or write us live on Facebook at The Verdict. Now, back to The Verdict.
And welcome back to The Verdict.
Welcome back.
This is a show looking to mix ESPN, unsolved mysteries, and the practice of law. We're getting into the David versus Goliath stories of the cases that don't see CNN, but they should. And we're disrupting the practice of law, showing that there's a better way than what's going on right now in the judicial system. There's a better way to the extent that we can practice with urgency. We as lawyers can hold ourselves to a higher standard to our clients and to ourselves. Because we're really talking about a lawyer's health as well as anybody else's. And we're using this show as a platform to talk about the ways that we can make the law more efficient, more client-friendly, and really support the health of all concerned on a win-win-win
Absolutely.
situation.
And also to encourage businesses to do the right thing. You know, you don't, again, there's enough to go around for everybody. You don't have to accomplish profit by breaching contract, not paying your vendors. You know, there's a myriad of ways to make money the right way.
Because actually, go look at what's going on, what I'm seeing in some businesses, whether they realize it or not. It's not just breach of contract that they're doing. The way that they're going about it turns out to be civil racketeering.
Absolutely.
Where they're actually breaking and they're violating criminal statutes by conducting the business the way they're conducting it. And when they're doing that, they're actually in violation of this racketeering law. And that law's got teeth. It allows myself as a lawyer to look into other parties and to expand discovery, and provides additional pressure that Sarah was talking about that can get cases settled. We're talking a little bit about unforced errors.
Yeah, this is a really
the
interesting
uncertainty principle. I've had a client recently that did a couple things that were unforced errors, but I see it all the time because we make mistakes. We don't when I'm thinking,
cost the case.
it cost the case going to trial the way that it was otherwise going to go to trial. So it's like even we as lawyers don't know what goes on in the minds of our clients. We don't know what the other side also is going through, okay? And I have had cases where there's been a request for production of documents against one of my large corporations, and I'm going through the discovery, and I'm like, they did X, Y, and Z, and I'm like looking at the document. Now, what do you do with that? You know, then you ask yourself, am I really supposed to turn this over? And there's all kinds of conversations that come up like that.
Right.
Now, if you have the possibility, I think, Sarah, you were talking about this in your cases as well. You're sending out this pre-suit discovery.
Right.
You're sending a pre-suit demand. What are your thoughts, or what have you seen as far as people willing to actually bite on that, to actually resolve a case before it actually gets filed?
The smaller the entity, the more likely they are to settle. If it's an individual, I've had success with pre-suit, but usually the bigger the company, the more they want to fight.
Why do you think that is?
Why? That's a curious thing.
It comes back to a cost risk analysis. You know, does it cost more to try to settle it now versus hiring a lawyer? And also the attorney fee provision. Attorney fee provision can actually be your friend as an attorney if you're a small guy.
Talk about what is the attorney fee provision.
Okay,
Please
so
educate the public
on this show, there's going to be some highlights. Anybody that's going out there in TV land, if you have a contract, listen, that you ever signed or that you are about to sign or that you're drafting to go into partnership with somebody else or that you're using for anything else, listen to what Sarah's about to say.
So
this is highly important.
So in Florida, you can only get attorney's fees one way or the other. Basically, either it's in a statute or via contract.
If you win the case.
If you win the case. And what that means is if I sue you and
Right.
I have to hire an attorney and I win, and I'm deemed the prevailing party, then you have to pay my attorney's fees.
What he just said and what we're talking about now is by far the most important thing that
Right.
we might ever talk about on the show. There's only a couple ways for a party to get attorney's fees, to win their attorney's fees in a lawsuit. And the reason why it's important is this. If I was to go by my billable hour rate at $4.95 an hour in some cases, that goes by pretty quick and it moves pretty fast. Now, if the other side is going to be required to pay that, it's only going to happen two ways. If there's a contract provision that says if there is a dispute between the parties on
Right.
this contract, the prevailing party wins their attorney's fees, that's one way. Might be a statute out there,
Right.
like Florida's Deceptive and Unfair Trade Practices Act, I mean, which says that unfair trade practices are illegal. That's another way to get your attorney's fees.
Right.
If you don't have that and you come into my office, it's a problem. And the reason why it's a problem is because an attorney looking at this is going to say, how are you looking to get paid for your attorney's fees?
So you can actually win but lose. And here's why. Let's say, for example, you're suing somebody for $30,000. Right? Just going to trial could well exceed that, depending on how complex the issues are.
Wow.
So you could end up in a situation where you win $30,000, but you got to pay your attorney $30,000, $40,000.
And I see that it's so...
So what can a person do if they don't have these provisions in their contract? Or, what are their remedies? How do they go about it?
Well, that's a very good question, and I could go on for another hour. What you do if you don't have it?
You know what? We're going
But
to
in
take time to educate the public and
Right.
do a show on it. Absolutely.
No, you can certainly, you can mitigate that, okay, through what's called an offer of judgment statute. Jay knows what I'm talking
Right.
about. But essentially, the Florida legislature created this mechanism whereby you want to encourage people to settle a case, and if they don't accept a certain offer by a certain dollar amount, then that would also trigger attorney's fees.
Right.
So that's the 2-minute
But
version.
you want to talk about,
Right.
pressure.
Thank
You want to talk about pressure, okay?
Right.
So if I'm looking into a breach of contract and possible civil racketeering, I have it two ways. I have the ability, if in the contract it says prevailing party gets their attorney's fees, I can get attorney's fees from the contract. If there is no contract, there's also Florida's Deceptive and Unfair Trade Practices Act, but the Civil RICO statute itself says if you are able to prove that there was a racketeering activity, enterprise, and all of the elements of civil racketeering are present, you win your attorney's fees as well. You want to put that whatever which way you're going to get your attorney's
Right,
fees
right.
into your demand letters, and
Right.
for your attorneys that are out there, and I've seen it missed time and time again, where it's just not there. And if you guys, and I'm just going to mention, if you guys doing anything on LegalZoom or anything, make sure it's there. I mean, it's so easy to put it into your contract. If you miss it, and you miss it forever, and it's not something that you can get back at the end of the case.
The most important question you can ask whenever you sign any type of agreement, does it have an attorney's fee provision?
Right.
Most important.
This is a fantastic takeaway for people who are listening, because I guarantee you that no layperson knows about
But
that.
this is not just for, I mean, for anything that you're talking about, anything from any contract that you're working on, anything that you're
That's
doing.
what I'm saying is no layperson would know, reading a contract, that should be there. And they don't know to look for that
Right.
necessarily, and they wouldn't understand the severity of it missing.
So so if you're looking at a contract, it's got to say someplace that if there's a dispute, the winning party or the prevailing party gets their attorney's fees. So that's basically what you look for. If it's not in your contract,
That's a huge
then
takeaway,
then
people.
if it's not there, it's not there. We have talked about the format of the show, and we're going to evolve with this. But one of the things that Sarah and I were talking about, adding and talking about the Supreme Court. And just a couple minutes about what we saw in this last term, and
The
what
court-
surprises that.
Always to bridge the gap between what's going on in law and what's going on with people, right? Because again, we want to, the way the perception is that there's a big gap between the law is over here and people are here.
Right.
No. It's all one and the same.
Right.
It's all one and the same. And as you guys wisely just pointed out, what you don't know is extremely costly.
So if we can get any information to y'all, this is a huge
What
takeaway.
was your biggest surprise in the final decisions of the Supreme Court this term?
So everybody understands, we're talking about the United States Supreme
Yes.
Court, first of all. It's the highest court in the land. There's 9 justices, and people like to categorize them as liberal versus conservative.
That's a big deal.
Depending on who
Very
the president.
political.
Yeah, because the president of the United States gets to appoint a justice if one dies or one wants to resign or what have you. And then what ends up happening is the Senate will approve it, and the Senate is usually political, and based upon their ideology, a justice will be deemed liberal or conservative. Now, the interesting thing about the United States Supreme Court is that once they get on the bench, they can do whatever the heck they want,
Right.
Because they're not elected. And so what's interesting is that we're deemed to have this conservative court now, meaning that 5 of the justices have been appointed by
Republican.
Republican
presidents
presidents,
versus 4.
correct.
But in theory, if you look at the decisions in this last term, they haven't necessarily gone along party lines.
I have to say, I agree with you. I'm surprised to see the where the justices are landing on their decisions, and I'm surprised to see where the Chief Justice has come in as a swing vote
Right.
on the
What
issue of the.
decisions are you all talking about specifically that are
The one that surprised
viewers
me
would be
was the
in-
administrative state, to be honest with you. The one
Administrative?
the one that allowed the administrative state, where administrative agencies are able to look at the federal regulations and interpret their own, make their own interpretations of federal regulations, which is basically the support of the administrative state, which to me would be a liberal issue. But that was a surprise to see the Chief Justice swing on a 5-4 in that. I think that was my biggest surprise.
Right. Well, you know,
What about
and,
you,
and,
Simon?
and also, well, for me, it's a funny one, but, you know, being able to trademark the term FUCT,
Ah, yes.
you know, there is a law back, you know, years ago that you couldn't trademark obscene types of things. And so this guy comes out with a shirt that says FUCT, and he's been trying to trademark it for years.
Right.
Goes all the way up to the United States Supreme Court, and in this term, they said you could trademark it. And, you know, again, the layperson would probably think, oh, that's a pretty liberal type of thing to do, but this was a conservative court
Right.
that allowed that trademark to go through.
Got it.
So that's just one example. There's many other decisions that have come out.
Right, so this is a really interesting one
where
as
the
well,
justice-
because this affects people and
Right.
how they're doing business day to day.
And where the justices are actually landing, I saw a really interesting article about the new appointees and where they were deciding how they decided their cases and where they landed, and they're not actually voting together a lot of the times, and it's actually extremely surprising
Right.
how that they've not actually been what they call appointee twins or something along those lines, where the same president has appointed both the justices.
Well, I think this is fascinating, and it also comes back to the fact that these are human beings interpreting the law
Right.
written by other human beings.
Right.
So no matter what anyone is wearing, if it's a black robe and they're in the highest court of the land, these are human beings doing human
And that's
things.
the thing is, you never know, and we're going to continue to talk about that uncertainty principle on this show. Thank you very much
Yes,
for
thank you to
watching,
everybody.
and we're going to be again traveling around, bringing to you the cases that no one else is talking about, giving a voice to those that are just joining the legal system with cases that are in South Florida, and talking about them. And Sarah, I want to thank you for being here again.
Thank you for having me.
Looking forward to having
Thank
you over as a guest and co-host. And I really appreciate your perspective. And Janine, as always, thank you for your take as the non-lawyer.
The layperson.
And we will see you again here Monday night, 6 o'clock. And thank you for watching The Verdict.
Thank you.
NN.
The following program does not necessarily reflect the opinions of the staff